secret that most people don't know. The scariest part of a bankruptcy case, the court hearing, it's usually less than 10 minutes long. In my court, it's like 5 to 7 minutes long. And in today's world, in 2026, it usually happens while you're sitting at your kitchen table, or maybe you're sitting right next to your lawyer in their office, all safe and warm and snuggly. My name is Adrienne Hines, and I take away shame from the bankruptcy process. I've been a bankruptcy lawyer now for almost 30 years. And today I'm pulling back the curtain on the 341 hearing, the Meeting of Creditors. This is that bankruptcy hearing that everyone's talking about after they file for bankruptcy. Most of my clients and my followers on my social media accounts are losing sleep over this hearing. And I think it's largely because they're imagining a dark courtroom and a judge in a black robe, but that is not the reality. So today I'm walking you through exactly what happens, the types of questions you'll be asked, and why exactly there's really nothing to be scared of, right? Let's go. So the goal of a 341 hearing is to do three things. A trustee needs to first confirm your identity. Second, they need to confirm that the information in your bankruptcy petition is truthful and accurate to the best of your knowledge. And third, they need to ensure that you haven't forgotten anything. And the reality here is that if you are who you say you are, that's an easy one, right? If you were honest and truthful when you filled out your bankruptcy petition, and I recommend you be honest and truthful on the front end, and assuming you have an experienced bankruptcy lawyer, you really have nothing to worry about. Really. Let's talk about the setting first. What does it look like? Where do you go? How does this work? Well, I've got great news for you guys. Since COVID, 341 bankruptcy hearings are all now held on the Zoom platform. You don't even have to leave your home in most cases. So to be clear, there's no judge in these hearings. Instead, you're talking to your bankruptcy trustee that was assigned to your case. You can think of a trustee as an auditor, not a prosecutor. Their job is to simply verify your identity and to make sure that your paperwork is accurate. And don't worry, if you're not sitting in your lawyer's office next to them, they are required to be on the Zoom call with you the entire time. Nice and safe. Okay, let's talk about the questions you're going to be asked at your hearing. Your bankruptcy trustee is required to ask a specific set of questions, and these questions are designed to be yes or no answers. So if I've done my job right, if your lawyer's done their job right, you should already know the answers to every question you will be asked. Let me give you an example. We'll go through the top 10, okay? Number 1, state your name and current address for the record. You see, not trick questions. Number 2, did you sign the petition, statements, and schedules in your bankruptcy? Number 3, did you read and review them before you signed them? Number 4, is everything in your paperwork truthful and accurate to the best of your knowledge? Number 5, did you list all of your assets, everything you own? 6, did you list all of your creditors, everyone to whom you owe money? 7, have you ever filed for bankruptcy before? 8, are you required to pay child support or alimony or domestic support of any kind? 9, have you filed all of your required tax returns? And 10, have you transferred, given away, or sold any property within the last 2 to 4 years? These are the big 10 questions. Most trustees are going to ask a lot more questions depending on what you own or where you live, but they're just as easy because you're being asked information that was actually used to fill out your own bankruptcy. Your lawyer has already asked you these questions when they filled out your petition. Now, we have to take a little detour here if you're filing a Chapter 13 bankruptcy, because in a Chapter 13, the hearing is very similar, but a trustee has extra things to ask you about. Let's just back up for a moment here and remind everybody a Chapter 7 bankruptcy is a liquidation. You are in and out within 3 to 5 months, and you don't pay any of your unsecured debt back. But in order to qualify for a 7, your household income has to be under a certain amount, or your state needs to have enough exemptions to protect out your assets based on the state where you live. So if you are filing a Chapter 13, you are going to be in it for 3 to 5 years, and you are proposing to the court a payment that you hope is going to take care of your debts and allow you to keep your houses and your cars and things. So for that reason, your hearing's not going to last 5 to 7 minutes. It's going to last 10 to 20 minutes because there's a lot more to talk about. You're going to be friends for the next 3 to 5 years with us. While a Chapter 7 trustee is actually looking at what you own in the moment that you file your bankruptcy, a Chapter 13 trustee is looking at your future. They're going to say to you, hey, can you afford the monthly payments that you've proposed in your plan? They're going to say, has your income changed at all since the moment you filed this paperwork like a month or so ago? And importantly, they are going to confirm that you're caught up on your domestic support obligations, your child support, your alimony, because those are considered to be priority debts and those need to get paid while you're in there. In a Chapter 13, a trustee just wants to make sure that your repayment plan is feasible and fair to both you and your creditors and everybody else who has an interest here. Okay, back to the hearing process as a whole. You might be wondering, hey, Adrienne, where are the creditors? It's called a meeting of the creditors after all, so where are they and aren't they going to jam my life up and isn't that terrifying? And the answer is, well, they almost never show up. In a typical consumer bankruptcy case, credit card companies, medical billers, banks, they don't waste their time showing up. This is their business model. They know people are filing for bankruptcy. They're predatory. Usually it's just you and your lawyer. You're having a 5 to 7 minute conversation about what's going on in your finances. And your trustee's job is just to step into the shoes of your creditors to make sure that all the questions that your creditors would have the right to ask are being asked. Your creditors are only entitled to certain pieces of information, so most people will never see anybody they owe money to once they actually file their bankruptcy case. Very unlikely to see anybody you owe money to at your hearing. That just really is not how it works. So, we've come to the end of your hearing. 5 to 7 minutes, 10 to 15 minutes, 2 to 3 minutes. Wherever you're located at, it's not going to take long. And when the questions are over, the trustee is going to say, this case is concluded. And that means that you get to push that little red button on your Zoom meeting that says, leave meeting. In a Chapter 7, we're going to wait for your final discharge, which is going to be issued sometime between 60 and 90 days after your 341 hearing. In a Chapter 13, you're going to continue to make your payments towards that fresh start that you're working for. And if you're nervous, that's okay. That's normal. That's what people like me are here for. But if you're ready to stop the stress and really start the process, you can click on the link in the description to book a shame-free consultation with a bankruptcy lawyer near you who offers free consultations. I created a bankruptcy lawyer referral network service for my followers for this reason exactly. I'm here to help you get your life back, so please don't forget to hit that subscribe, that like, that follow. Ask me questions. I'm not a gatekeeper. Welcome to my content.